When we talk about judicial review in the American constitutional system, we usually describe it in counter-majoritarian or anti-democratic terms. But in Federalist number 78, Alexander Hamilton gives us a different way to think about judicial review. He describes it instead as judges functioning as guardians of popular sovereignty, of the settled will of the people. Let's unpack that a bit. Hamilton argues that the Constitution should be considered a fundamental law, that is, a law of higher authority. Laws passed by legislatures are just ordinary law. When these two come into conflict, Hamilton says, any person who's charged with interpreting or applying these laws should give preference to the Constitution, the fundamental law, over a piece of legislation or an executive action. It's just ordinary law. Now, in this sense, why do we say this involves judges acting as guardians of the popular will? Well, because Hamilton says the Constitution's fundamental law precisely because it's unique in its connection to the will of the people. When the Constitution says, "We, the people of the United States, do ordain and establish this Constitution for the United States of America," that's in the preamble, it's stating that the Constitution is an act of we, the people. Ordinary laws are acts of the people's representatives in Congress, and they may or may not represent majority will. In fact, we're quite familiar with legislative processes that don't always give us outputs that fit with what the public wants. Nor would we want to proceed on the basis of, Facebook polls to see what people want. So instead, the Constitution gives us a way of collecting the people's settled will. That is their assessment of what powers they want to confer on government over the long haul and what limits they want to place on the exercise of those powers. And that represents the will of the people in a basic and fundamental way that ordinary laws just don't. Now, why should judges be charged with the responsibility of enforcing this fundamental law? Well, Hamilton argues that the reason judges are an appropriate depository of this is because, one, the judicial task is itself interpreting law, that is, discerning the will of the lawgiver and giving it effect in particular and sometimes unforeseen circumstances. This is what judges regularly do with respect to ordinary law. With respect to the Constitution, he says, we can trust judges to do this, to be guardians of the settled public will expressed in the Constitution, precisely because judges don't have any of the ordinary means of political power. He says they wield neither the sword, like the executive, they don't have the force of the community, nor do they hold the purse strings. That is, they can't control the public fisc, the public resources, like the legislature does. Stack on top of this the fact that, at least at the federal level, judges don't stand for re-election. And so the will of a temporary majority, some sort of passing whim of the moment, doesn't really function as a determinant of their views. This actually leaves them quite weak if you think about it. They don't have the claim to the control of resources, they don't control the force of arms in the community, and they can't even say, we've got a public or majority mandate from the last election. So what's left to the judge? What power do they have? Hamilton's pointing out here that judges really only have their legitimacy in the eyes of other office holders and in the eyes of the public. That is, judges wield the power they have. They can successfully engage in judicial review. They can only successfully claim to be guardians of the Constitution insofar as all of us actually believe that they're doing that in good faith. So Hamilton says, this is why we should trust judges to function as guardians of the settled will of the people expressed in the Constitution and to enforce that will against the temporary majorities that are expressed in the legislature, at least in theory.